Freeze! Immigration Customs Enforcement, put your hands in the air now. Lace your fingers. Put your hands in your hair now. Everyone, put your hands in the air now. Lace your fingers. Put them on the back of your head. All right, how many of you have ever experienced that? No, you don't answer that. How many of you have seen that happening on TV? Yeah, everybody has, okay. Julie's mentioned, national security and things like that, that, the reasons why we control stuff for export and import. But for us as exporters, the one thing that we want to avoid is that. I mean, the very first thing we want to support our country and national security and et cetera, but that's the one thing we do not want to have happen is having the Bureau of Immigration Customs Enforcement with their FBI counterparts and Department of Justice coming into our company. I actually was hired by a company in Southern California after that happened to them. And when that happened to them, they did it first thing in the morning. They came in guns out, and they 200 employees on campus that day. They herded all of the employees into the cafeteria, held them there for 8 hours. The empowered official for the Department of Defense side of it, they manufactured both dual use and ITAR controlled items, was not on the campus, so they had to hold people there, and actually the president of the company wasn't there either, so they held everyone there while the officials went through to make sure that they locked down the computers and locked down the areas to get the evidence that they needed. They had been warned by the Department of Immigration Customs Enforcement and Department of Commerce on, I don't know, 3 different occasions, I think it was 3 different occasions in a 5-year period for shipping to sanctioned entities in Syria. They also, they ignored it. They also had a gentleman who was their head of marketing and their named empowered official who was a U.S. permanent resident but a Chinese national. And he had ties back to China, and they were trying to set up a manufacturing plant in China as well as sell to there, and there was defense articles that they knew they needed an export license for, that they got actual emails from his computer that said, no, let's send it around this way because we can't get a license for it to ship it. He's now serving time in jail. The company itself has spent over $5 million on compliance. They hired a big company called Vestera, which changed to J.P. Morgan Chase. They're actually cooperating with the Department of Justice and the Department of Defense, and they actually helped with a sting operation in China 2 years ago. They started out with no compliance program. They just had an empowered official in name. The shipping department was using DHL as a shipper, and they didn't file any EEIs, automatic export shippers, because they thought DHL was doing it. They didn't even provide a shipper's letter of instruction to tell them to file AES. So today, I'm going to give you a lot of information. Julie gave you quite a bit on the export regulations for the Department of Commerce, and I'll fly through that portion of it. And I don't mean to overwhelm you. I just want to show you how much is out there for export and import, and the reasons why you need some kind of a compliance program, making lemonade out of lemons. It may look hard, may look like there's a lot out there, but you can boil it down to a compliance manual and processes and procedures, and it pretty much can keep you on the right track. Okay, so here it is. So you'll see what I'm going to go through. I'm going to give you an overview of the government agencies. I'll stop in a few places that I think might be interesting to touch on in the Department of Commerce side and talk about anti-boycott provisions, because that's another area of compliance. It's not just about getting licenses or using exceptions or exemptions. It's also complying with the FCC if you're sending something out on a temporary basis, or the Bureau of Alcohol, Tobacco, and Firearms if you're sending guns or gunpowder. It's also about HTS, harmonized tariff schedules, and Schedule Bs. Any one of those things can stop your export or your import, and that's the totality of a compliance program. Then I'm going to talk a little bit about sanctions and OFAC. Then I'll get into the Department of State information, and their penalties, exemptions and penalties, and talk a little bit about import regulations and documentation. I have a picture of the red flags that we can share. And then I have some backup slides because of the Department of Commerce stuff that will go over the export reform a little bit, because they're going to be dumping a whole lot of stuff into the Department of Commerce side that is controlled by the Department of State right now. Okay, why do you have to be concerned with export-import controls? Because you have to comply with all the different U.S. government agency regulations. You do not want to have a visit by any one of those agencies, including the Department U.S. Customs, because they'll come in and then when they do an assessment audit, they're there a long time. Department of State comes in, they're there 3 or 4 days. It has a bad effect as well, but Customs is there a really long time. The DOJ, the Department of Justice, and Department of Commerce have increased enforcement since 9/11. The DOJ, the Department of Justice, launched an enforcement initiative, and they right after that happened is when you saw BAE in the news a lot concerning Saudi Arabia. And that was the very first case. It was a case that was being tried over in the UK. The UK dropped it. The Prime Minister said, we're not going to pursue this any longer. And then we picked it up. You don't want your name in the news. And then there's a multi-agency task force around the country. The DOD, whenever every company I've worked in, I've had a clearance. And you have an audit. You have audits from everybody. The IRS comes in. The DCA comes in. You have internal audits. Then you have the Department of Defense coming in for your security clearances, and they want to know everything that you've done with everybody else. So, all right, Julie covered this. What is an export? It's an actual transfer of goods, technology, or software by any of these means. And it doesn't matter whether it's military, commercial, or dual use. She talked about dual use, but I'll give you a really good example. How many of you have the phones that when you turn it sideways, the view turns with it? And inside there is an accelerometer that measures that. Well, that accelerometer can go into a crash car dummy to measure that movement. It can also go into a missile. So your accelerometer in your phone is a dual-use item. And again, we talk about it's to a U.S., to a foreign person, company, or country, or to a national within the United States. We don't call it, on the Department of State side, it's not called a deemed export. Doesn't matter, it's the same thing. And then again, it's also controlled, both commerce and state control for re-export. And somebody asked a question earlier about that. I, as a compliance consultant, advise that up front in your paperwork, when you give we respond to a request for information or an RFP for proposal, you put in there that your products are controlled, and then when you get the final purchase order or contract, there's wording in that contract as well, that especially for distributors. Okay, under the ITAR, defense article is an item that was originally designed for military purposes or modified for military purposes. The end use really doesn't matter for ITAR-controlled items, the International Traffic in Arms Regulations. Under the ITAR, dual-use items if it has neither, has been designed for military application, or has been modified or adapted for military, it will fall back up into the ITAR. These are examples of what's controlled in the ITAR and the ITAR. I mean, technical data are marketing descriptions, performance system specifications, PDR and CDR packages, even for your speaker, if it was controlled, your speaker. Operations manuals, because that gives technical information. The interface control documents, assembly instructions, and the hardware platforms, subsystems, assemblies, components, down to coils, the little copper things that go into RF microwave products. Tooling and test equipment. When you're sending equipment over across the border to your maquiladora, if you want them to manufacture something and you have an extra piece of equipment, instead of purchasing a new one, that has to comply with all the export and import regulations. It also has to comply with the regulations for NAFTA down below. I haven't put NAFTA in here yet. And then these are examples of technical assistance and defense services. Anything physical that has to do with your export controlled product. This is the definition out of the ITAR, but you can use it for the ear as well, because if you're testing something and you're performing a service on something that's controlled to the and allowing that thing, telling your customer in that country that might be a denied party that this works, you're making a violation. You're not in compliance. Co-design, co-development, you want to work with somebody across border. And I happen to know of a couple of guys that are engineers that are Americans that are down in Rosarita working on software boards, designs, and they have other engineers that are Mexican nationals working with them, but the information is being sent down to them across border and by email and things like that. When you invite a foreign customer to a design review or just to visit your plant, and they walk through, and you don't have a compliance program in place, and they come up and they look at this and they say, hey, what is this? And it's controlled for the ITAR, it's controlled for export for some, and you start telling them about it, and they're looking at it, they're touching it. You've made an export to them. You've got to be very, very careful. Okay, we talked about public domain a little bit. It's anything that's published and generally accessible, available in libraries, at the university. It's any basic fundamental information that you would find in a library or at a university or in newsstands, bookstores. You got to be real careful though, because certain magazines that they publish now, defense, I forget some of the Aviation Weekly, things like that. There have been articles that go in there that they didn't clear and actually gave out information, technical information that was controlled.
Excuse me, if you post it on your website, that's not considered public domain?
Yes, it is, because it's accessed by, so there's ways about posting it that you can get it cleared through government agencies. If it's ITAR controlled, you can go to certain DoD agencies to run it through to get it cleared for public issuance. Or if you can go get your CCATs, your commodity get a commodity jurisdiction first, and then a commodity classification from Department of Commerce, then you can publish it. But I wouldn't just put it out there unless you know it's a telephone or a ball or something that's really innocuous. I really hesitate to tell people to self-classify on items that might have controls. You have to look through the whole thing first.
Give me a question on what falls under has to be regulated information. For example, the name of a program or platform, the suppliers that are,
Exactly. When you have a contract, like a DoD contract, or it doesn't matter, it could be a commercial one, but under DoD, Department of Defense, and the three-letter agencies, you might get a contract where they say a non-publishing clause. And so that it falls outside the actual export controls, but they can go ahead. I'll give an example. They can, Department of the Air Force will say you can't talk about the name of a program. You can say there's a customer, but you couldn't talk about the name of the program. And then if you do, they can go ahead and say, all right, we didn't like what you just did, we're going to debar you. Freight forwarding companies in the last month and a half, there was like 6 of them, were debarred by the Department of the Air Force for just price fixing. It had nothing to do with exports. And the Department of State picked it right up and said, okay, you can't do business with these freight forwarders, which made them scramble, and like 3 of them have been taken off the list so far. The others are working for it. So you could be doing something that's totally not outside the arena of exporting or importing, and you go against something that the U.S. government wants you not to do, and they can stop you from exporting.
Will the government give you notification that a component in a product, let's say for example, a product is manufactured, components are manufactured abroad, brought in for assembly, for re-exportation, and you want to know whether any of the components have a dual use? Will the government provide you with some notification that it is or is not, or are you required to know what the...
No, the government will. You can go in for a commodity jurisdiction for a foreign made product. Once something hits the U.S. soil, it's under our control. So when you go to export it, you treat it like it was made in the U.S. for jurisdiction, classification, harmonized tariff schedule, everything. I talk a little bit about harmonized tariff, but not much. On an import, and when you go to re-export, if you import something from a country, you import it under their if it's a permanent import, you import it underneath all their information, including their harmonized tariff codes. And then when you go to export it, then you have to make sure that, I mean, if it's got a laser in it, you know, there's certain controls when it comes in and when it goes out for both the Department of Commerce or the Department of State, depending. You've got to get it classified in either jurisdiction and classification, like Julie spoke about. So you have to treat it like you own it when you get it, when you go to re-export it.
Are there any areas where there is an enterprise zone or a zone where you're deemed to be exempt because of either the nature of the product or you're doing it just for...
Yeah, there's what are the actual title of the zones? It's a warehouse zone, but usually it's a finished good. It's not something that you do anything to. It comes in and sits there.
Okay.
And then it goes back out again. You don't do anything to it. Once you get it in your possession, then you have to treat it like as the importer of record. You have to treat it like you're as the exporter of record that you own it. All right, we talked about the jurisdiction earlier, but I wanted to just give it a good example of it. A Humvee was originally designed for military purposes, but now you can buy a Humvee. I mean, they're not the same anymore, and they actually went through a process to get it considered changed. But so you can't buy just they have these auctions that you go to, and you can buy a Humvee. If you want to sell it to somebody in Mexico, you have to get the proper export clearances to do so, and you have to know what the jurisdiction of it is before you do that. Okay. Just a little decision tree. I think we're making these slides available somehow. We'll tell you about that. So just a simple one. Do you know the jurisdiction of your product? No, then submit a commodity jurisdiction. Unless it's very simple, a fork, a ball. But if it's got some kind of electronics in it, or it can be dual use, you should really be safe about it. Julie spoke about the fact that once you get something on paper, although I have to add a caveat to that, you're pretty much safe. And I got a commodity jurisdiction, and they put it in what they call the miscellaneous category. Then I tried to ship again. I got a license, miscellaneous category under the International Traffic in Arms Regulations. So I needed to get a license for it. Got a license for it, tried to ship it, and the U.S. Customs and Department of State stopped it because they thought miscellaneous is like what they call other in the HTS codes. They don't like it. They think you haven't given them enough information. Okay, so if you do know the jurisdiction, is it IR or ITAR? If it's IR, you go to the decision tree. I don't know how to do this, but I had a link here where I have another decision tree that we can go to in the slides to look at it. And if it's ITAR, then you submit a license to the Department of State. That's real simple. And if anybody is of Indian background, please, I didn't mean to make any kind of derogatory anything. I just wanted to show you, this is a couple that got married in the United States. So are they a U.S. person or are they a foreign person? You don't know. Okay, what is a foreign person? It's any foreign government. It's any foreign corporation or organization that is not incorporated here to do business in the United States. And it's also any individual who is not a U.S. citizen or a permanent resident, a green card holder.
What about dual citizens?
The United States doesn't recognize a dual citizenship. Once you become a U.S. citizen, you're considered a U.S. citizen. Other countries recognize dual citizenship, but the United States doesn't. So, this couple here were married here in the United States, but he was born in India, and she got a fiance visa to come over, and she was born here. So can I transfer controlled information to her? She was born here,
Yes.
and he has a fiance visa. Can I transfer information to him? No, you're right. Denied party screening. She talked about that a bit. There's besides there's the 7 list. There's a whole bunch other out there because of the Wassenaar agreements and things like that. The U.S. government has actually done a consolidated screening list for the 7, and the new website called e-Customs. And you can go there if you get the PowerPoint presentation. This is a link to it, but just put in e-Customs, and then you put in consolidated lists, and they download something, and then it can check those lists for you. If you are dealing with, say, you're foreign owned, like Cobham is, and you want to make sure that you're complying with other regulations outside just these. There's companies out there like. I'm sorry, this is export.gov is the U.S. one. E-Customs is one of the examples of a commercial company that does screening for you. You can screen for travel. You can screen so when you're going to speak at a seminar and you know the people there, or visitors coming to your place, or whoever you're shipping to. Embargoed and sanctioned countries. An embargo is the complete ban or prohibition of trade. Right? That's a complete prohibition of it. So I'm going to have a list that comes up, shows you the combination of all of them. And sanctioned countries are trade prohibitions on certain types of products or countries or individuals. So that's the difference between an embargo. You're usually going to be denied, period. Iran, Syria, those are examples of complete denials. You're never going to get a license for there. Unless there's some kind of real need, then you have to go and get a presidential approval. You can't go through the State Department. You have to go straight to the president. I combined the list of embargoed and sanctioned countries so you can see where they are. They have varying policies. There's an asterisk. You can get medical supplies into North Korea. Lebanon is like Lebanon. It's like to the regime that is trying to bring down the democratic government. You can send stuff to Lebanon, to a company in Lebanon, but if they're not on the list, that denied party screening, you can't send to them. And it's the same with the Democrat. Is it Congo? No, Liberia. That's the ex-regime of Charles Taylor. So there's some are just specific to certain areas. Others, you can't send stuff to Venezuela right now or Sri Lanka without getting some kind of a extra special approval. Foreign business travel. All right, you guys, how many of you traveled and bring your smartphones or your laptops inside and outside the United States to Canada? Sometimes you get emails on there and it's maybe discussing an issue, a technology. That is an export. There are things that we can do, and there's examples of things, like, again, the laptop computers, the Blackberries, the PDAs, any models or mock-ups that are, even if they're scale, if they're made of the same kind of materials or something like that, they would be controlled. Defense-related software, they're taking your laptop so you can go demonstrate some kind of great auto-routing system for a UAV. You need to get an export license, an ITAR export license for that one. And then giveaways. You may, if it depends, on what it is. It could be in short supply. Most of the time it isn't, but different examples, flyers, things like that. They may be controlled if there's information on them. If you don't vet your data sheets first, get them cleared, you might be making an export. Yes.
Does it have to be a commercial activity as a threshold, or if you go over there to do training for something that has nothing to do, but on your laptop you have information, you're not transferring it, you have it in your possession. Yes, you're taking it into another country, but there's no commercial activity involved.
But sometimes on your computer, yes, it depends on what kind of training you're doing, right? But sometimes on your computer you have other work. Right. It could be controlled, or there could be software in there that's encrypted, you know, and so there could be other parameters that you have to take a look at what you're carrying. I have to tell you, before I got into the business, my husband worked for the General Atomics, and I went to visit him over in a country over in the Middle East, and I thought I was and I hadn't been involved in export compliance of any kind or import. So I went to them and said, "Is there anything I can take over? You know, help out with? You know, do they need anything?" They gave me some EPROMs, which are it's like firmware, you know, to take, and that had ITAR controlled stuff on it. I mean, after I became involved in this, I thought, oh my God, I carried it through customs, and I went through 3 countries, changed airports in France, and there's 2 other countries in the final destination, with my 7-year-old son with me. Which meant if that and that was like the stuff that they were doing was ITAR licensable, and they had what they call a technical assistance agreement. If anywhere along that route somebody decided to stop me, I don't know what I would have done, because I don't know where my son would have gone. My husband was, that was before they had international cell phones. I mean, it was like 94. I mean, they had them, but it was, you didn't, carry them on a normal basis.
But when you mean stop, you mean U.S. Controls?
Customs immigration in any one of those countries, including U.S.
That relates to the U.S.?
Well, no, it doesn't matter, because the Wassenaar Agreement and other different agreements and arrangements that we have export controls as well.
Oh, okay.
So you have to consider the totality of the program that you're in. I'm telling you now, but this was a long time ago. So don't be reporting me to Immigration's Customs Enforcement, please. Anyway, so laptop letters, if you're carrying a laptop, will do a lot of give you a lot of assistance, because there are exceptions that you can use, and some exemptions that you can use for personal use under both the IR and the ITAR. That you can make a statement in this letter that you hand to those customs officials. All right, some interesting points. Go ahead.
So that letter, so if you're going to travel overseas, you're going to take your computer, do you recommend just having that letter?
Oh, yes, I have. Oh, yeah.
That way, it's not a question. You just prepare that and take it. I've never even thought about that.
Right. And part of the compliance program, as I've created them and where I've worked, travel is not only authorized by your manager and whoever else is in that chain in your company. It also goes to the export-import person, so that they know where you're going. They ask what you're taking. They can create a letter. They can check to see if you need any kind of export approval of any kind for what you're taking as well.
Just thinking practically, what if you're accessing your company server from the foreign country through a VPN and not downloading anything to your laptop?
If there's no one looking over your shoulder, you're not making see, there's other things you warn about when you do a travel brief. It's like you don't know what you don't know. Who's accessing, if it's wireless, if it's whatever that you're using in the room, who can access it. So you've got to be very careful when you might be making an export and you don't know it. I've had the president of one of the companies I work for had his laptop removed from his hotel room. They took out the hard drive, copied it, and put it back in. And they found out about it later, because he was having issues back when he was back here in the United States. They found out how that was done, and he had a lot of information on there.
Excuse me, when I'm looking at the last part where it says each separate knowing and intentional violation, gross negligence, that suggests that you have to have a requisite intention or knowledge, and some gross is simple negligence is just you do it.
You do it once, shame on you.
So
do it twice, shame on the exporter.
So, if you knowingly violate it, that's where you're going to run yourself into difficulty. If you are engaged in a benign activity and incidentally have it, I would argue that that would not come within, because you don't have the.
They'll, you know, when they come in and do an investigation, they'll ask you, have you had export training?
Ignorance is not bliss.
Right. You know, so I have to say that of a lot of the all the voluntary disclosures I've ever made, because I've made quite a few to the Department of State, because something, you know, inevitably something happens like that. The guy brings back a tool that was controlled that he didn't, you know, or he went over there to actually fix the equipment over in a country and came back with a part that was broken. And when you bring something back, you have to import it in under, you know, certain export exemptions or licenses. So things happen, and I've never, in any of one of the voluntary disclosures I've ever made, had any kind of a penalty. They'll give you the letter saying, yes, we note that you did this, and et cetera, we'll just keep this on file. I have to say the Department of Commerce does a lot more prosecutions than the Department of State does currently. They have more resources, I think, out there, and they do a better job of actually having people in all the communities, you know, representatives in all the communities, and make people feel more comfortable about talking about, you know, my boss told me I had to, you know, ship something.
Is there an affirmative obligation to get the train, you know, you establish intent if you have an obligation to
as an exporter, you're obligated, period. You have to have that. It's like she said, ignorance is not acceptable. You're again, but but they usually don't prosecute for or give a penalty, or, you know, for something like that. It would be if you did it 10 times in a row, 5 times in a row. Then that's starting to look like gross negligence.
And then also, that's why having a compliance program, if you can show that you're trying to do the right thing.
Exactly, it goes.
Mitigate some of that.
That's
You can get
exactly.
mitigation, but the problem is, if you just go blurry along, running along, and you say, "Oh, I didn't know," well, you're supposed to learn. You're supposed to get training or know that you're supposed to know.
Exactly.
So if you have a program that helps mitigate potential, even if they come after you, you can mitigate it. Well, I got the program. We just aren't quite along
Yeah.
where we, you know.
Under the ITAR, you'll see. I don't think they publish consent. They don't have consent decrees under the Department of Commerce. They'll publish the violation and the results. You can go on the site. You can go on this site, and you can actually see a lot of what has taken place. Most of those are intentional. You know, like they're trying to ship an F-14 engine to Iran. You know, but. And on the other side, on the ITAR side, they have what they call a charging letter, and then a consent decree. And in that, that's what they'll say. I have some penalties up here. You're going to pay $400 million in penalties, but $6 million or $10 million of that will be in a compliance program. You know, so they mandate it. Oh, wait, yeah. So here's some interesting export-import facts. You can't. It's illegal to sell, import, distribute, transport dog or cat fur in the United States. Did you guys know that? I mean, it could be on the cat or the dog, but if you take it off the cat or the dog, you can't do anything with it. You'll get in trouble. All right. Kinder eggs are sold all around the world, except here in the United States. You can't, because there's a rule, a regulation, an act, I should say, the Federal Food, Drug, and Cosmetic Act that says you can't embed toys in confectionery. So don't bring that egg in. I mean, don't. You know, they sell things here. So you can have it in a plastic little egg so you can see through it, but you can't bring it into candy.
What about Easter? They sell these things.
They probably are manufactured here in the United States, or they get some kind. You know, you can't import them. All right, here's another interesting fact, and this is my last one. If you're going to ship a horse by sea outside the United States, you got to get an export license from the Department of Commerce for it. But if you send it by air, you don't have to. Right? But when you send it to the country like the UK or the European Union that's going to go compete in the Olympics, you need a passport for that horse. And then when you bring it out of that country, you need an export license to bring it out. So, you know, and I'm not trying to overwhelm you. You just need to have, you know, knowledge of those things. Okay.
Judy, isn't it true that the horses, the part of the horses is an old license because they were exporting horses for what was the reason? Military reason?
Oh no, it was for, you know, the reason why by ship is because they take them for slaughter for food.
Okay.
And then you can carry a lot in a ship. It's cheaper to do it, and they'll take them to another country that eat horse, and so it's really a.
Is there still a regulation in the book that says that certain countries you can't do horses because they could use as military against us?
I don't know. I don't know.
They've never taken it off the books.
That'd be interesting. I don't know that.
There's a lot of old things that have never been taken off.
Yeah, it's like you can't spit on the sidewalk and yeah, type thing.
They've just never taken it out.
Yeah. Yeah. So here again, she went through the agencies, the U.S. government agencies that we deal a lot with. OFAC, I'll talk about in a minute. Department of Homeland Security and CBP, which the alcohol, tobacco, and firearms. You have to pay attention to that because if you're shipping a tank howitzer with the gun on it, you not only do you need to get a Department of State license under the ITAR, you'll need to get a license from the Bureau of Alcohol, Tobacco, and Firearms because it's a gun. So I just wanted to give you a picture of the Department of Commerce. You didn't have one of those, Julie. You didn't have the picture of Department of Commerce on there?
Yes, you did.
You did? Oh. She talked about this. The Department of Treasury is where Office of Foreign Asset Controls and the Bureau of Alcohol, Tobacco, and Firearms are. Department of State controls the sale, export, and retransfer of defense articles. That's what you call them items under the Department of Commerce. We call them defense articles. So whether it's physical, hardware, if it's software and technology, they're put together, and then any thing that you do physically, training or any kind of service you perform, they are all referred to as defense articles.
Excuse me, question. On the Department of Treasury, if a product or service is being funded by a bank or an institution that may have links to, how does the financing part come into play when you're going to get a license? Do they ask questions about how it's financed? Or
Yes. Oh, yes.
Okay.
Your payments, yes, that's under Office of Foreign Asset Controls.
Letters of credit where you're going through banks, which essentially are a step away from the actual customer. Are they focusing on the banks, or are they focusing on the customer in the bank?
They're focusing on everyone,
Okay.
every party to the transaction. That's what. Right. And so that's why denied party screenings. You need to know every party to the transaction. And who said that they are the importer of record, and then they send it on in Mexico? Yeah. So you are maybe the importer of record, but you're re-exporting what you're getting to somewhere else, and so
Sometimes.
So you have to be aware of so you have to be aware of who the parties are, who you're selling them to. Again, I saw a video of a Immigration Customs Enforcement bust up in Bakersfield. And they had F-18 parts and things like that. And I was working for General Atomics at the time. One of the General Atomics divisions makes those machines that bust up kidney stones, right? And inside it, there's like a laser. It was in that group of things that were in the warehouse that they busted into. And I'm looking at it going, oh my gosh! And we were expecting them to come to ask us where it came from. They never did, because I guess they found the trail, the paperwork trail or whatever. But the guts of that machine could be used for all sorts of purposes. Other dual-use purposes other than what it was made for. Okay, so we have this. This is her. I took this right off the BIS site. So guys, if you're doing a compliance program, they don't mind that you guys use everything that's on there. When I go through the export control reform, A lot of the stuff that's going to come over from the Department of State, they're going to do, when she's saying this is sequential, they're talking about making this like a 600 series, like 606, so it identifies it as coming from the ITAR. This is an example of what you would look at. So you're looking at polygraphs under this ECCN. And then the reasons for control is crime control. And you have to look for it under country chart 1. And then are there any license exceptions for it? No. And then it talks about, you know, if there's anything else that goes along with it, if it's in kilograms or things like that. This is a very simple one. The ones that are in the ear, like she said, you can, it's very straightforward. You can say gives you the parameters of so many degrees of radiation hardened whatever, and if it can take so many temperature degrees, and if it's a chemical, what the solutions are. So it's really precise, and it's easier to actually classify it under the ear than it is the ITAR. And here's an example of the country chart. So you want to send it to, let's say, Honduras, and crime control in the column 1, there's an X in there. That means you need to get a license for it. There was no exceptions listed at all, so you have to apply for a license. Okay, and there's the general prohibitions again. Those are very important because not only after you do everything, I know Julie said it, but after you go through all the other things, knowing what the product is and who it's going to, there might be one more something under the prohibitions that won't let you send it. There are situations that can involve release of U.S. technology, tour of laboratories, foreign national employees, and especially in the Department of Defense side of it. But if it's and the deemed export of the commerce side of things, you have to get an export license. There's a new changes in the regulations about that. That's why you need to keep, you need to know someone who stays on top of it for you. If you're wearing dual hats, especially contracts and exports, sometimes it's hard to stay on top of those things. Hosting of a foreign student, interns from universities, big time. A lot of universities get funding from places called DARPA and Navy research labs and the Air Force research labs, and there's different layers of funding. Some layers, it starts out with just basic research. Don't need to have any kind of export approvals for that, usually. Then it goes into fundamental research and it starts to get gray, and then it goes into application, these different layers of funding. It's called 6.0, 6.1, 6.2. You got to be very careful when you bring an intern into your company. Think, with a bright intern with all this background, does great research, and all of a sudden you need an export license, or you didn't know that and you've already had him working on something. These are the penalties. It's a fine of $250,000 per violation for civil penalties, and a denial of export privileges, or twice the amount of the transaction. Criminal penalties, I didn't put enough zeros, did I? A fine not to exceed 5 times the value of the exports or re-exports, and or $50,000, which is greater. I think that's flipped. I'll get that straight before we actually give it out to you. Other penalties are listed in the regulations, as she talked about, and it may result in statutory sanctions, seizure and forfeiture, debarment. Oh, here's the chart. So this is a really good one. I know this is like what they call an IEXAM chart, but it's something that you can use in your compliance program. This again is from the BIS site, and it's very helpful. All right, here's an example. A company called WaveLab Inc. It was in February and October of 2006. They're in Western Virginia. They exported power amplifiers. CABA makes power amplifiers to the People's Republic of China without the required licenses. And they were controlled for national security reasons, which means it was under the Department of Commerce. And they got an $15,000 criminal fine with $85,000 criminal forfeiture. And they also were denied export privileges for 5 years. You know, in today they might look small, but it's really not. But for smaller companies, you know. Armor Holdings. Armor Holdings is actually part of BA Systems now. In 2001, 2004, they sent handcuffs, riot helmets, and fingerprint equipment and face shields without obtaining the required licenses from Bureau of Alcohol, Tobacco, and Firearm and International Traffic in Arms regulations. They got a little over $1 million penalty. This company is based in California, and they release technology for aircraft parts to Iran. So, you know, it's very easy.
Any controls to Russia? I was surprised not to see Russia.
Oh, yeah.
Okay, because you see China, you see Cuba, but, you know, because
I think they were on the list.
Okay.
I didn't have that list of countries that I had.
No.
Not by OFAC.
Yeah. No, they're not a.
Well, that list was a combination of all of them.
Okay.
All right, anti-boycott. There's a law that says that you can't do business with any company that asks you to boycott another entity like Israel, and that you have to report it. And then that's the nutshell of that. What that says.
Judy,
Mm-hmm.
on that, like Israel, the anti-boycott, I have a client that shipped some, they were systems, it was a rack system of computer stuff going to Saudi Arabia that was to use to identify oil production, and it was measuring all that. But when they shipped it over, they packaged the units, they repackaged it at their warehouse, and on one of the boxes they bought a part from Israel that came to them imported, that went into the unit, right? And they reshipped this, they redid all this stuff and reshipped the parts. And in one of the boxes that they shipped, it said made in Israel on the box. So when it gets to Saudi Arabia, they stopped it. The engineer went over there to help install this equipment, right? They did everything legally except that this made in Israel sticker was on the box, right? Well, the guy got arrested. The engineer got arrested.
In Saudi Arabia.
Saudi Arabia.
Because of their laws.
Because of their laws, right? So there's anti-boycott, yet it really wasn't that, but it turned out to be that because of the name.
But his responsibility, his company's responsibility, and once he was released, is to report that to a U.S. government agency that controls it.
Well, what they had to do is they had to identify that part. They had to take those units, ship it back to the U.S. or ship it to another country, and then do some they finally got it done. But
see, they should have stopped work right then.
you know.
They were supposed to have stopped work with that right then. So these are the conduct prohibited under the regulations: refusing to do business, taking discriminatory actions, furnishing information about a business, blacklisted persons and firms. So, furnishing information about associations with charitable or fraternal. There's other ethics rules as well that go along with this, that talk about trying to get a contract by bribing officials. And this is the Office of Foreign Asset Control. She kind of went over it. I want to get to the ITAR because we're kind of running late. These are the ones that are all the different sanctions that are imposed, whether it's humanitarian or, like the regime of Charles Taylor in Libya that he killed a lot of people. These are the civil penalties. I won't go over them. You can read them when you get it. Okay. The Department of State is responsible for the control and permanent and temporary export of military defense items. They are modified or actually designed for it under the Arms Export Control Act. And we use what's called the United States Munitions Control List to have just like the CCL for the items that are controlled. If an item is on the USML, it's governed by the ITAR, and it includes items that are defense articles that are specifically designed or developed for military application. I need some water or something. But it's also by statute. Commercial satellites were under the Department of State, then they were under the Department of Commerce. Now they're back at the Department of State, and they're commercial satellites. And one of the reasons is some foreign governments, and even our government, US agencies, DoD agencies, will buy space or time or whatever you get off of a satellite on commercial satellites as well. Okay, this is, we love triangles, don't we? So this is how the amount of things you can share with who you can share them with. For a U.S. person, there's a lot of stuff that you don't need an export license for unless they're overseas with a customer or something like that. And then as you get into the foreign persons, if it's a non-U.S. person with a temporary U.S. work visa or no right to work in the United States, this means above this line you need export licenses or export approvals, exemptions to be able to share a defense article with. Okay, so there was 9 categories in Department of Commerce, the CCL. There's 22 under the ITAR. And then inside of that, they have letters A, B, C, and D, kind of like the CCL. But the A is, they talk about things like if it's an airplane, if it's an engine, if it's technical data, if it's, those things like that. They have exemptions, they're the same as exceptions in the way they work. Under the ITAR, hardware exported pursuant to a manufacturing license agreement or a technical assistance agreement, those are those export approvals you get if you actually perform physical activity of a controlled defense article. Spare parts, if you're bringing something in for repair, there's an exemption to bring it in to repair and send it back out. There are exports to Canada. There's a whole section under the ITAR that allows a lot of activity to take place. That's defense services and technical data, not hardware, without getting an export license. So in the same thing, you can immediately do it if you can use the exemption. And there's a few more exemptions coming up out of this whole export control reform. This is an example, the repair exemption, and you can bring it in a period of up to 4 years, and then repair it, and then you have to return it. I have other different examples of it: repair, replacement, enhanced, upgraded. It has been rejected for permanent import, so it comes to the United States, but you say no, I don't want it. Then there's an exemption that like the DoD agencies will issue you that says, okay, you can share technical information and sit down and perform a defense service with this customer for this reason. And it's usually in conjunction with a program that you're working with the DoD agency. And you get a letter for that. It's kind of like using a laptop letter, but it's a letter. And every time you actually make an export, you have to it's your responsibility to keep a list of those exports. There's a foreign military sale exemption. So the government goes through this whole work with a foreign country, and then they choose a freight forwarder. The freight forwarder then does not need to get an export license to ship there's no export license needed. They just file a thing called a DSP 94 when they're shipping it. These are the examples. There's one license for Department of Commerce right now, and there's more than this. There's a DSP 6 to a DSP 5, a DSP 62 to a DSP 61, because when you need to make changes. So anything for a permanent export license of hardware or technical data is under a DSP 5. A TAA and MLA, warehouse distribution agreements, where you're sending stuff overseas. These are the physical agreements the physical activity that you do. If you're temporarily exporting something out for a trade show, that's ITAR control, you have to have a DSP 73. Now, when they get to the export control reform, that's what they're trying to do, is go to one single agency, which will take a long time, but the other stuff that's happening right now is really good news. ITAR penalties, it's up to $1 million per violations, up to 10 years imprisonment, and $500,000 per violation for a business unit. This is per individual, and suspension of export privileges. Now, it says per violation. writing the contract, sitting down and discussing what the customer wants, making it, shipping it, and then going over there and training on it and then testing it could be considered, it's not one, that's like 8 violations, right? So, and they're getting, now it's not just the physical shipments, the physical things that you do. If you don't maintain records, like when you get a technical assistance agreement, to sit down and actually figure out the design of a product, and you don't keep records of when that meeting was and what you actually passed on, they're really starting to come in on and penalize on those things. Here's BAE Systems, the $400 million case where they defrauded the United States and made false statements on the Foreign Corrupt Practices Act. That Foreign Corrupt Practices Act is the one that says you shall not do anything that would enable a contract be made because you've influenced the foreign party. Get them tickets to a football game, give their daughter a new car, that kind of thing. And they got a $400 million. That was the highest penalty that's been issued by the Department of State ever. This one is kind of a commerce and an ITAR violations, and it involved the illegal export of U.S. Electronic items to China, and counterfeit items, and also the import back into the United States. And it was from a company called by these two guys, Ming Zhang and Policarpo Coronado Gamboa. He sounds like a gangster. It was in Rancho Cucamonga, and he exported them with dual-use items without an export license. They were going from U.S. They were used in U.S. Army tanks. So Gamboa pleaded guilty and was sentenced to 5 years probation. Was ordered to pay $13,600 and give restitution to the Sony company. But there's another issue in here, which is counterfeit. The U.S. government agencies that do contracting now have a big issue with counterfeit parts, a big issue. And that really isn't an import or an export issue, but it falls under that arena of the things that you're doing, and having to be aware of. Hughes Electronics and Boeing. There's another company called Loral. They were launching a satellite together over in China, and the missile didn't work. And so Hughes Corporation, before it was owned by Boeing, and Loral decided to figure out what went wrong with it and shared that information with the Chinese so it wouldn't happen again, so they wouldn't waste the money of failed launch, et cetera, et cetera. And Hughes Boeing was fined $32 million. Loral was fined $20 million, and the VP of engineering for Loral was debarred from working in any government program for 4 years, which kind of ended his career. All right, import compliance here. Before September 11th, I hear all the time, well, we didn't ever do it that way before. Well, they did. Once after September 11th happened, the export and import regulations became a lot stricter, and vigilance on those regulations, what was coming into the United States, grew exponentially. Why do you do import compliance? Because you need to have for the same reasons you do export compliance. They'll stop the product coming in. It'll be seized. It'll be put in a warehouse. You'll be charged for it. You might not be able to get it to incorporate into another product and deliver to your customer. And you can pay. I'll give you another example of what happened with General Atomics in a minute. So the other things you have to consider, we talked about the harmonized tariff code, the proper country classification for the country of origin that determines the HTS and how they assess duties and taxes. If there's a license or permit required, permanent imports into the United States is governed by the Bureau of Alcohol, Tobacco, and Firearms for ITAR controlled items. There are certain exemptions on there, like the airplanes and things like that, but there's an import list, United States munitions import list. You have to look down it and find it. It's got the same kind of categories as the USML, so it's easier to look through once you have the knowledge of it, to see if you need an import license if you're bringing it in permanently. Radios, military radios, we buy a lot from, or BA bought a lot of military radios from Marconi in Italy to put into F-16 test stations to communicate with the airplanes. They're controlled, and they're brought in permanently. Even though we didn't know where the airplanes were going after that under an FMS, it was a permanent import. And maquiladoras, we permanently import things all the time. It's easier. Some are controlled and some aren't controlled under a license. And the fines and penalties can occur for any of them. In import compliance, they talk about this too. The FCC, the FDA, if you're bringing in a TV or something that has a laser in it, the FDA is involved. You got to clear it to them. If you're bringing in a laptop, TV monitor again, the FCC is involved because of the stuff inside, and you have to have the proper FCC markings before you can, on the documentation before you bring it in. Every person who is in the business of manufacturing has to register. If you manufacture a defense article, you have to register with the Department of State. Unlike the Department of Commerce, and it costs money to register with the Department of State. Also, it costs money to do export licenses with the Department of State. In the beginning, they charge, I think it's like $250 a license right now. But then as you do licensing, they look what you did the previous year and they charge you that for the next year. Record keeping, you have to keep all items that are imported for 6 years. Anybody who's in the business of, I didn't cover that in the other part, but anybody who's in the business of actually facilitating a sale has to register with the Department of State, even if you're not part of that company. So you go help a foreign country sell something to a foreign customer, you have to register with the Department of State as a broker.
Does that also apply to attorneys who do business? Let's say attorneys who go to countries to try to either manage or dispute resolution. Do they have to register?
It depends on what they're doing. If it's like, it depends on what they're doing.
If they're not acting as an agent or distributor.
Yeah, there's a definition in the ITAR that talks about what that definition is that you need to be aware of. There's the fines and penalties involved, again, $10,000 or imprisonment for not more than 5 years. That's very nice, so you only have to go 3 years to prison instead. All right, what's the cost? It's not worth the cost. It's you get your name out there. You know, BA got their name out there. Boeing's, all the time you're hearing that, there was a contract for the tankers. And whenever you get bad publicity, people don't want to do business with you. And it develops a reputation for export and import violations, which means every time you go to send something out of the United States, U.S. Customs, there's a system there that says, check this guy, check this individual, check this company, check their paperwork. And again, like Julie said, exporting and importing is a right, not a privilege. This talks about export documentation. If you need an export license, it has to be filed with U.S. Customs. You can't just get the export license and say, I got it. It has to be filed with U.S. Customs before you can actually ship. You always need a commercial or pro forma invoice, a bill of lading, an airway bill, a packing list, a country of origin certificate if you're declaring NAFTA. On all the documents, you need statements. If it's you're declaring an exemption or exception under the ITAR, you need to put the statements on there, and I recommend them for the Department of Commerce products. The EEI, the AES, you have to file it before it goes. There are certain exceptions still for ships, but I'm not real good up on that. I can get research that can get up on it. You have to file for anything that's over $2,500 on the Department of Commerce side, and everything that's licensable on the ITAR side. So you have to file that AES filing. Import documentation, it's still same thing, bill of lading, airway bill, carrier certificate, a commercial invoice, an entry manifest, packing list, the import license, which has to be lodged if you need it, and a country of origin certificate if it's required. When is it filed? The importer indicates a tariff classification and pays any estimated duties and taxes, and a surety bond. Everybody has to have a surety bond when they're importing. And if, like with the maquiladoras, at the end of it, if it's all estimated, you have to file a reconciliation at the end of every year. There's just, we're talking about the required statements. Yeah, it says, say, if you're temporarily importing for repair, you have to put something like 22 CFR 123.4A applicable. In your compliance programs, you should have these processes in place. You have the actual manual that says you shall do this, you shall do that, and then you have processes and procedures. That makes it really simple. You just go to it. You go to, Other requirements, if a license exception or exemption is utilized, there's the example for it. Record keeping for ITAR, 5 years, regardless of whether it needs an export license or not. If you're using an exemption, you have to keep everything. You need to keep your financial documents, your contracts, your shipping bill, your bills of lading, everything. It can be kept electronically as long as it can be printed out. Red flags. I have all the red flags listed for you. She gave examples. And I have little red flags. So you can refer to them. There's lots of them. How do you stay out of trouble? Know if your your transaction is controlled for export. Know the jurisdiction. Know the classification. Know who the end user is. Know the red flags. If it's a bakery and they're ordering RF microwave parts, Joe's Bakery doesn't usually need those. And have a program in place. Easy. That's the hard part is putting it and getting the program in written, and the process is written. Once you have them, it's just like an assembly for a bicycle. Well, some people find it hard to put a bicycle together. I understand.
Excuse me. As far as the dual use, when you go in for your classification or your justification, if we had an IP intellectual property that we sold, we built for an OEM, they actually used it in third tier as far as supplier auto program. So they put it was a little speaker that they put a little segment that got sold to somebody else that put it into a radio transmission receiver, and then that unit got sold into a subcontractor on a defense program.
Mm-hmm.
So it was third tier down. Our customer.
Yeah, it's not your. It's the final. The final integration is entity is the one responsible for obtaining any export or approvals. And the other point I wanted to make was the Department of Commerce will give you a commodity classification if you send something in. And they used to they would just give it to you. You would fill it out as complete as you knew it. It had to be all true information. And they would never question a shipment. Customs wouldn't question. Now they do. So the Department of Commerce puts a disclaimer that says, we're going to give you this classification, but this doesn't mean that it falls under our jurisdiction, if you've self-classified. I'm paraphrasing.
Question. I would put an indemnification clause and prior notification clauses in all your contracts so that if in fact you have it. But my question is more general. With everything that you told us, why would someone export?
Why would you want to be
right? And I say that because the Obama administration is trying to double exports, and I think clearly there's a revenue base that is available. But everything that you're saying is a disincentive for anybody who is trying to, because the cost associated is significant. So I think it would be helpful if you.
Gave you some reasons. I think that's why I was talking about the compliance program. If you have a compliance program in place, it is not, you just do it by rote. Anybody can come and look. It may take them a little while to read through it and go find the process to do it. once you get that down on paper, and if it's a small company, and you're dual, triple, quadruple headed, you should be able to go and talk to your management and say, let us have a consultant. Let us have someone we can call. But you also have the Department of Commerce you can call, and you have the response team in International Traffic and Arms Regulations. AES has a help desk. But you always should have someone pinpointed, and with that compliance program in place, it makes it a heck of a lot simpler. I mean, we'll talk about it in a minute. I think we'll leave the export control reform. Go ahead, Julie.
Just export control reform. But another point, why do you want to export? Yes, because I always say that. At the end of the day, I hope you still want to export, because 95% of the world's population is outside the United States. So it's a huge market. And once you get your compliance program, we've talked about so many different things for so many industries. It becomes very rote for your specific product or industry.
Exactly.
You know, yes, you have all these considerations, but for your particular RF, microwave, whatever, golf club, it's very easy.
Yeah, because you're not making it's harder for freight forwarders than it is for the Joe export.
With the export control reform, it's probably after the break, the idea is to simplify, make higher walls for fewer products, single agency, single list, single enforcement, single IT platform.
And we're kind of running out of time here, so I don't know if I want to just leave it on the slides, or do we want to go through the export control reform real quick?
We can take a break and come back and ask questions. I think one of the things about why to export, it is good for the economy, it's good for your business. This sounds all shaky and
A lot. It sounds like a lot of.
All that is great, it's a lot. You know, as a freight forwarder, our job is to help you to do that. The Department of Commerce job is to help you. You know, the consultant's job. You know, there's a lot of help out there. World Trade Center, we're here. The World Trade Center is here to help. So there are people to help you. So you don't have to do all this yourself. You don't have to spend a lot of money to do it. You just have to make sure that you're getting good information.
You need a little time.
And it takes some time, and just be aware of it. A lot of companies just want to ignore it because they think they say that, you know, and then they don't do anything. And it's not that hard. It's just being aware of what you're doing. And what
Well, a good example is IRS. You have to comply with the Internal Revenue Service. You have to comply with Human Resources. You have to comply with OSHA, and they all have a lot of different things. And they all, in your companies, usually have a person at least identified to handle that, right? At least to know what that is. You should have that in your export and import areas as well, because it's the same kind of regulations that you have to comply with. And once you do it by rote, it's not hard. I mean, with the maquila at Cobham, we exported. There was at least 3 to 5 imports a day and 2 to 10 exports a day to Mexico. So that's what, 15 a week, 60 a week of importing, and then exporting about the same. And it was all down to, you know, procedures, processes, real easy. So I think what I'm going to do, the only thing I'm going to say about the export control reform is they're going to go to a single list, but right now what they're doing is their DoD has gone through all of those 22 categories and is removing 90% of what's on there over to the Department of Commerce, and they only are required to go a 30-day notification to Congress. There's no regulation that says Congress can stop it. So they're expecting all this to be reported in June, and then eventually what they're going to do is they're going to, from what they were talking about, they're going to go to the same kind of five-digit alphanumeric number, right?
That includes the ITAR?
Yeah. Yes. Eventually, that's eventually down the line. But right now, when they go to a single, entity, single control list. But right now, what's happening is they're going to a single IT, and they're going to a single licensing form, and they're moving a lot of products over to. They'll be moving a lot sometime this year. They're anticipating moving a lot of product over to the ear. 90% will move over to more flexible lists. 50% will be eligible for license fee treatment. 35% will continue to require an export license, but will be eligible for an exception. There is an exception called STA, the Strategic trade authorization that was created just for this. If there was no other exception available, you can probably export under that. They have a consolidated screening list we talked about. You can go to export.gov. And the positive list means that you're only going to be this much controlled instead of, this much of a triangle controlled. This just telling you what they've looked for. Satellites are by statute. It's going to take a while for satellites. And that's it. I have elements of an export management program in the back end of these slides so that you can try to start building your own. And if you get mired into it a little bit, there are consulting firms out there that can help you. World Trade Trends can help you. And thank you very much.